Hello, everyone. This is a World Arbitration Update, and this is our day 2 of World Arbitration Update. This is the Africa Day, and with my co-chair Ian Laird, we're really excited about this World Arbitration Update 2022, which has, as you know now, an emphasis in the MENA region. And we're simply absolutely excited that we're all here. I would like to thank our sponsors, without whom we wouldn't be able to make the World Arbitration Update a sustainable endeavor. So thank you all of our sponsors and also all the supporting organizations which are in our website. And I would like to just take a moment to thank also my co-chair Ian Laird, who is a co-chair of the International Dispute Resolution practice at Crowell and Mooring, but also a professor at Georgetown law faculty on issues of investment arbitration and public international law. In my honor with me. So Ian, take it away, and this will be a fantastic panel.
Well, thanks very much, Jose Antonio. I've been really looking forward to this panel and to this day in the week-long schedule of World Arbitration Update. We have 19 panels this week. We had a great first day yesterday. Today we have 5 programs, and this is the second today. The title of today's program is Legal Developments in Arbitration in the MENA region. And MENA has become, over the last 15, 20 years, very active in international arbitration. Of course, that's a reflection of the incredible growth of the region. Construction arbitration involving corporate matters, international investment arbitration. It really is a very dynamic and fascinating place for those practicing in the international arbitration field. And today we have a fantastic panel, which really, I think, reflects the whole philosophy of the World Arbitration Update, which is to provide a focus on areas of the world where international arbitration is absolutely active and vibrant, outside the typical centers of the Parises and New Yorks and so forth. We really take pleasure in highlighting the fact that there's some fantastic practitioners, arbitrators, and centers which deserve every highlight. And we hope that this panel will play part of that objective. And it's my pleasure then to introduce my colleague, Ms. Randa Adra, who is moderating our panel today. She'll introduce the panel and start things off. Randa is a partner of mine at Crowell & Mooring in our New York office. She is a highly experienced arbitration practitioner and litigator in New York. She's worked on multiple investor state arbitrations as well as commercial arbitrations. And I really appreciate, Randa, you taking the time out of your busy practice to come here today and help organize this fantastic panel. So I'm going to pass it off to you, and I'm really looking forward to hearing from our panelists. Thank you so much. And Randa.
Thanks so much, Ian. Thank you, Jose Antonio, as well. I am so honored to be here today. Good afternoon or good morning, depending on where you all are out there. It's such a pleasure to be here today with everyone to discuss some fascinating legal developments in arbitration in the Middle East and North Africa region. We're really excited to have everyone here with us. And as Ian began touching upon in his introduction, despite ongoing turbulence in the MENA and surrounding regions, earlier this year, the World Bank estimated that the region's economies will grow by 5.2% in 2022. And that's the fastest growth rate since 2015. Uncertainty from COVID, the war in Ukraine, inflation, and other supply chain disruptions are all factors that impact stakeholders and investors in the region. And it's with this backdrop that we observe that arbitration is on the rise in the MENA region. In fact, there's a notable shift in MENA towards promoting and supporting arbitration. Today, we will discuss the waves being made in arbitration in this region, where the tides are turning, and what practitioners and other interested stakeholders should keep in mind and expect moving forward. I am honored to introduce this distinguished panel of speakers that plan to cover all of these topics and more with you all today. And because our time is limited, I'll keep this brief and I won't share all of the accolades and experience of this group, but I encourage you all to look into their bios, which are quite impressive. And I'll begin with Khushboo Sharadpuri. Khushboo is a senior associate at El Tamimi and Company's arbitration department. She is a dual qualified lawyer admitted to practice in both Singapore and New York. Her practice focuses on multi-jurisdictional litigation and international arbitration. She's represented both companies and state entities in a wide array of disputes pertaining to the construction, infrastructure, energy, real estate, and shipping industries, among others, and under the rules of all major arbitral institutions. Jumping to our panelists today, I'll begin with Gianna Hamedi. Gianna is the founder of her firm, Gianna Hamedi Attorneys at Law, a boutique law firm in the UAE, specialized in cross-border dispute resolution, among several other practice areas. Gianna is a UAE licensed lawyer with the right of audience before all UAE courts, including DIFC courts, and she is an expert in both civil and Sharia law. Moving on to Mustafa Alamuddin. Mustafa is a partner at Zulfikar and Partners in the firm's international arbitration group, based in Cairo. Mustafa is licensed to practice in Egypt and specializes in both commercial and investment arbitration and has represented clients in a broad range of arbitration matters before the leading arbitral institutions. And last, but of course not least, Professor Ilyas Benfica is Professor of Transnational Law at Hamad bin Khalifa University, a member of Qatar Foundation in Doha, Qatar, and Adjunct Professor of Law at Georgetown University, Edmund A. Walsh School of Foreign Service. He also regularly serves as an arbitrator in commercial disputes and is a prolific author of hundreds of peer-reviewed articles and 20 books. And before we begin with Khushboo's presentation, I want to encourage all of our participants today to please chime in with your questions throughout our discussion. We want to hear from all of you. We hope this will be engaging and dynamic for everyone. And after each panelist presents, we'll do our best to answer any questions we receive about their presentation so that we can keep things interesting and change it up a little bit. And so with that, we'll dive right in. I'll give the microphone to Khushboo and she can kick us off with her presentation.
Thanks so much, Randa, and good afternoon, good morning to everyone joining in today. It's truly a delight for me to be here today to share my perspectives on arbitration updates in the MENA region. What I'd like to do is speak about the broad themes that have emerged in the region over the last few years. And it's safe to say that the region has witnessed some discernible changes. Some of these developments have truly revolutionized the arbitration landscape here in the region, while others have significantly propelled it towards becoming a pro-arbitration jurisdiction. So we'll start with the UAE, given that it is the view from our window today. The developments in the UAE's arbitration landscape started way back from 2018, when the federal arbitration law was enacted. Now, one of the notable features of this federal arbitration law was that it repealed the previous Article 257, which exposed arbitrators and experts in the UAE to criminal sanctions if they fail to perform their duties with objectivity and integrity. And these are really broad and ambiguous terms by itself. So obviously, there was lots of concerns by people coming in to arbitrate. And what the UAE arbitration law did was successfully to repeal it. And this concern was obviously then minimized, or is actually negligible at this point. And that was really the start of the UAE's changing arbitration landscape. What happened since then, there have been lots of pro-arbitration judgments, which we'll speak about shortly. But last year was really the milestone year for arbitration in the UAE. Before September 2021, there were three main arbitral institutions in Dubai. So we had the DIFC LCIA. Some of you may know this. DIFC is the offshore common law system that's carved out here in Dubai. So the DIFC LCIA was actually a JV between the DIFC in Dubai and the LCIA in London. We also had the Dubai International Arbitration Center, as well as the Emirates Maritime Arbitral Center, which was a sort of a newish arbitral center. So this was before September 2021. Well, from September 2021, there was this decree issued, and I know Diana will speak about this more, so I won't go into too much detail, but just to give you a little bit of a flavor of what's been happening in the UAE, what this decree did, it's called Decree 34 of 2021. It abolished the DIFC LCI as well as the Emirates Maritime Arbitral Center, and essentially it consolidated both these centers under the existing Dubai International Arbitration Center. So that's all I'm going to speak about this, and I'm sure Diana will engage you more on this really interesting development. But in tandem with Decree 34, the Dubai Arbitration Center also issued a new and revised arbitration rules, which took effect very recently, a few months ago, from March 2022. And I thought it might be worth to briefly touch on some of the notable features of these revised rules. So, for instance, where the parties had not agreed on the seat, now these new rules provide that the DIFC would be the initial seat, which would be in a way akin to the default seat. And then tribunals are then allowed to determine the seat eventually, notwithstanding that DIFC would be this initial seat. And there's also a really interesting alternative appointment process of a sole arbitrator or a chair, where parties have failed to nominate a chair or a sole arbitrator within the time limit provided, or they have not agreed to a mechanism. For instance, what the center would do, which is the DIAC center, it would communicate to the parties or the co-arbitrator, if it's the appointment of a chair, a short list of at least 3 suitable candidates, and then each party or each co-arbitrator would then add 3 candidates of its own to this list, and then rank them in order of preference, and then return this list to DIAC without copying in the other party or the co-arbitrator. So I thought this is quite a novel provision because it allows the arbitral institution to retain control over the choice of the appointment, yet there's greater input that's given from the parties or from the co-arbitrators. Another notable feature in these rules is the recovery of legal costs. Now, the definition of costs has been somewhat controversial in the UAE because it wasn't clear what legal costs actually entails. So this development actually filled in a lacuna and explicitly provided for the parties' legal cost within the definition of cost. And this was something that the courts have been battling with, and such an absence was actually highlighted back in 2013, where the Dubai courts had actually issued a judgment against the recovery of legal costs or legal fees in the DIAC arbitration, because the previous version of the DIAC rules didn't actually have anything explicitly provided on it. So I think this is a particularly welcome development by the arbitration community, especially by lawyers, of course. The rules also play more emphasis on technology. So I'm not going to go into much more detail, but it explicitly allows tribunals, for instance, to actually consider holding hearings by virtual communication. It allows tribunal to sign awards electronically. And it also provides that all communications are to be made by email in accordance with an electronic case management system implemented by the center. So all of these are very innovative rules, which obviously reflects the progressive nature of Dubai and of the arbitral center. Another interesting or notable feature is the threshold for expedited proceedings. It's currently at 1 million dirhams. And obviously there's a way that this can be increased or decreased in the future, but it's a relatively low threshold compared to, say, for instance, the ICC rules, which is currently at USD 3 million. So in a way, the DIAC rules wanted to sort of carve out a manner for ensuring the small claims are dealt with expeditiously, saving time, saving costs. So this is all for DIAC rules. In terms of judgments, and while generally there's been really pro-arbitration judgments, I think that there are 2 cases that came out last year which are worth just to touch on really quickly. One of the cases related to it was an arbitration, construction arbitration, which involved a number of joint parties, involved the engineer consultant. There was also an insurer involved because there was an accident that occurred in the development. Now, only one of the contracts had an arbitration clause and the others did not. And what the Dubai Court of Cassation actually did is it held that because the defendants would be jointly liable for any claim, they were not able to divide the case between one defendant and the other, and hence it just sort of took jurisdiction over the whole case, notwithstanding the arbitration agreement. There was another similar ruling by the Dubai Court of Cassation, which very similar along the same lines I just mentioned, where there was a construction and a consultancy agreement. The construction agreement didn't contain the arbitration clause, while the consultancy agreement did. And in this case, the main liability actually pertained to the construction contract, which didn't have the arbitration clause. So The courts again took jurisdiction over the whole case, notwithstanding there was one part of the agreement that had an arbitration clause. It is possible that the courts would have decided this case differently if, say, the liability for the main liability pertained to the consultancy agreement, which didn't have the arbitration clause. But again, it didn't, and this is where matters stand. And from my perspective, this is really about where the courts need to find a logical means of dividing the claims. And to the extent they are able to, they usually would do it from my perspective. But notwithstanding these judgments, there have been some really, really positive pro-arbitration decisions by the Dubai courts. In another recent case by the Dubai Court of Appeal, the tribunal actually had decided there was no jurisdiction, or it had no jurisdiction over a consolidated arbitration over 6 distinct contracts between the same parties pertaining to the same project and containing the same arbitration clause. The courts actually set aside the tribunal's negative award of jurisdiction, and it decided that it had jurisdiction to hear a consolidated arbitration. This is notable because there was nothing in the DIAC rules, neither was there anything in the UAE arbitration law that provided for consolidation. So the courts actually proactively decided that this was possible, and again, very pro-arbitration and something to be noted. Before we move on from the UAE, I think there's just 2 institutional developments that's worth noting in the UAE. So the first one is the opening of the ICC Case Management Office in Abu Dhabi a couple of years ago, and the memorandum of cooperation that's been signed between the PCA in The Hague and the ADGM Arbitration Center in Abu Dhabi. So this is obviously, it's paving the way for greater collaboration for arbitration-related initiatives. We see a lot of very interesting workshops and conferences being organized in Abu Dhabi by way of these memorandums and cooperations. Now I'm going to move on to Qatar. I think the climate in Qatar has shifted considerably. The pro-arbitration judgments that are being issued by the courts is actually discernible. And this is also discernible in the legislations that have been issued as well. So the present Qatar arbitration law was enacted in 2017. And since its enactment, the Qatari courts have really reaffirmed the limited grounds that this act has to set aside awards, which is in Article 33 of the Qatar arbitration law to those who are interested. Similar to the UAE, Qatar has 2 different court systems that coexist. So we have the local Qatari courts that are run in Arabic based on the traditional civil law system that Qatari laws are obviously modeled on. And Qatar also has a common law system that's carved out within the Qatar Financial Center known as the QFC. So we have the QFC courts that are modeled on common law, and the judges in the QFC courts are all from common law systems. But this is where the similarity between the UAE and Qatar probably ends, because Qatar only has one national arbitration law, the Qatar Arbitration Law, which allows parties to choose either the local Qatari courts or the QFC courts as the supervisory courts in Qatar-seated arbitrations. This is slightly different from the UAE because the UAE have the UAE Federal Arbitration Law, which applies to onshore arbitrations that are seated in Dubai. So we say Dubai or UAE, but we mean the onshore system. And then we have the DIFC arbitration law that applies to arbitrations that are seated in the DIFC. We also have the ADGM arbitration regulations that apply to arbitration seated in the ADGM. So this is another financial free zone in Abu Dhabi. So it's quite distinct the way the Qatar arbitration system and the UAE arbitration system is sort of modeled on. Professor Lias will go on to more detail about Qatar, so that's where I probably should stop. But I think some of the recent judgment I've seen in my practice that's worth noting is back in 2012, let's say, so 10 years ago, there were challenges that were just based on any possible reason that parties were coming up with that were accepted by the Qatari courts. So something that's been spoken a lot about is awards being issued in the name of the Emir of Qatar. For many years, Qatari courts actually allowed both local and foreign arbitration awards to be set aside on public policy grounds if they were not issued in the name of the Emir. And Qatari courts relied on certain civil and commercial procedural laws to do this. At some point in 2013, this was actually brought one step further by the courts, where the courts not only refused enforcement, but actually annulled a foreign ICC arbitration awards that was seated in Paris for the same reason. And this is notwithstanding that a foreign arbitration award can't even be set aside by the Qatari courts, but they did that. So since then, the courts have come a really long way. Now, the first step of this progression towards a pro-arbitration jurisdiction, I'd say in Qatar happened, I think, in 2014, where the Qatari courts ruled that foreign awards did not need to be issued in the name of the emir. And then the Qatar arbitration law was enacted in 2017, and that's been really positive for the awards that have been coming out from the Qatari courts. The judiciary right now is extremely pro-arbitration. It's becoming increasingly difficult to actually set aside arbitration awards, as well as tribunals' positive jurisdiction awards. And we see this in all the cases I've been. Every time we have a challenge, it might not have a good ground. Even if there's a slight ground for a challenge, the courts refuse to accept it, because as long as there's an arbitration clause, they think that's the forum that the party should go to. So this is all I think I have to say for Qatar. And moving on to KSA, I think KSA is another jurisdiction to look out for. It's gone through a considerable shift. The judiciary is definitely becoming increasing pro-arbitration. There were some statistics that were actually released from the SCCA, which is the arbitration body in Saudi Arabia, which the study actually revealed that there were, out of 100%, say, applications that were filed to set aside awards, 94% of these applications were dismissed, and only 6% were accepted. So that's a very low number that were accepted. And I think, if I'm not wrong, the grounds that these applications were accepted were on public policy grounds or to do with contravention in Sharia law. So a very limited grounds that the courts were accepting. The Saudi arbitration law is very progressive. Excuse me. Parties can appoint any arbitrator, any mediator or expert, so there's no limits, there's no bar to nationality, to gender. In 2019, the Saudi government actually issued a royal decree which encouraged all government entities and state-owned companies to settle their dispute with foreign investors through arbitration. And this decree actually explicitly mentioned arbitration through the SCCA as the first option to resolve disputes with foreign investors. So we see the shift towards KSA also trying to open up its doors to arbitration, especially when it comes to arbitrations involving a local party and a foreign party. Now, I thought I'll also briefly touch on two other jurisdictions in this broad MENA arbitration landscape that I wanted to cover. So Oman's arbitration center, which is the main arbitration center, actually released arbitration rules in 2020 and mediation rules in 2021. Now, unfortunately, I don't think there's any landmark decisions coming out from the Omani courts, but the fact that these rules itself were issued shows that there's some sort of impetus within the government to push arbitration. In Iraq, so Iraq recently ratified the New York Convention in 2022. There's some possible disconnect that people have spoken about between the Iraqi Code of Civil Procedure, which gives court considerable review powers, and the New York Convention, which obviously doesn't. But this is something which we need to see how the courts will play this out when they have, or when they're deciding on setting aside of arbitral award cases before the New York Convention in the courts. So this is all I have for my broad spectrum. So I'll hand it back to Randa, who will take this forward. Thank you.
Thank you so much, Khushboo. That was fascinating. And I really appreciate you providing us all with an overview of all of the changes that have been going on across, various countries within the region. I think the country perspective is super interesting, but there's also a more industry related perspective that's equally fascinating. And I think it's no secret that the majority of cases in the Middle East region generally are linked to infrastructure. Infrastructure related disputes are often what we see, especially large, valued at very large amounts oftentimes. So we talked about at the beginning in the introductions, both Ian and I, that there's a lot of change going on in the MENA region and in the global economy. Inflation, supply chain delays, escalating material costs as a result of some of these changes and as a result of the pandemic. How do these changes, and this is directed at all the panelists, how do these changes impact arbitration in the MENA region, and where do you see those changes going? Do we think that this will impact the arbitrations that we're going to see in the region in the future? Will it not really have a big impact on the region? I'd be interested in the group's thoughts, and perhaps we can start with Mustafa just to get your initial thoughts, and then we'll go on if anybody else has anything else to add.
Thank you, Randa. Yes, as you remember, we were working on a case together, and it was related to a mega construction agreement that was to be performed or executed in Egypt. And yes, the mega construction projects and the infrastructure projects surely trigger a lot of disputes in the MENA region. And Egypt is now launching mega construction projects everywhere in Egypt, and in pretty much every sector: electricity, pure construction, solar energy, everything. So speaking about this infrastructure projects and the agreements that are concluded between the government and the Egyptian government, or the Egyptian entities and foreign investors, this could take me to the first point I would like to speak about, which is a new development in relation to the framework that governs the arbitration agreements in these contracts. As you may know, the Egyptian government has issued in 2019 a decree, a cabinet decree, organizing and governing these arbitration agreements. According to this decree and its amendments, any governmental entity and any company where the government is contributing, and even with a very marginal percentage or shareholding, should apply for an approval before entering into any agreement with a foreign investor, and this should, as long as such agreement includes an arbitration agreement. And very recently, this was only on 13 September 2022, so this like 14 days ago, an amendment to this decree has been issued, and this is very important because the amendment adds a new provision that could be problematic for many persons, that could be also useful for others. The amendment says that the governmental entities and the companies where the government is contributing with any shareholding should apply for approval before terminating any agreements where the foreign investor is a party with the government, as long as such agreement includes an arbitration agreement. This could be very interesting, in particular if we will go back to the case we were working on, because it was in relation to an agreement that has been terminated, unlawfully terminated by the government, and the arbitral tribunal by the end of the day has decided that the termination was unlawful. They would like to avoid such a situation again by studying the documents of the case and everything before such an important decision is made, in order to avoid any repercussions. As you remember, this was a huge award on damages for a group of foreign investors in this case. So this could be progressive and could be also seen from the other side as something that make everything centralized by the government. No one can take any action before applying for this High Commission of International Arbitration, which is constituted from people from different backgrounds, mostly executives, with very little contribution from people with legal background. This is the first development that relates to the issue that you have just asked me about. I would also like to go very quickly to another point, if this is okay. Otherwise, we can listen to other.
Yeah, I'd like to get others' perspectives on the question first before we jump to Egypt, and talk more in depth about Egypt. But Khushboo, did you want to add anything on the infrastructure related question?
Yeah, sure. So, I mean, I think that you touched on a really interesting point. I mean, we see this a lot in practice, because when it comes to infrastructure and construction projects, you know, there's a chain that goes upwards in the contractual relationship towards developers and consultants, and then it goes downwards. And not all of these related contractual chains necessarily have arbitration clauses. So what we see in practice a lot is related proceedings being filed by related parties before the courts in litigation. So for instance, the contractor has an arbitration clause with a subcontractor and we have an ongoing arbitration, but then the upward chain doesn't. So there's related litigation proceedings being filed in the courts. This is again fairly common because developers and employers of projects are often government or semi-government entities. And in the Middle East, they usually have litigation clauses as part of their contracts. And we see lots of challenges on the basis that related claims or issues are being heard by the court. So as a way to either suspend the arbitration, protract it, or sometimes just to derail it intentionally. And then what I touched on earlier was quite relevant because I spoke about these two Dubai Court of Cassation judges, Court of Cassation judgments where the courts had, took jurisdiction, even though there was an arbitration clause. And there have been decisions where the courts have actually upheld arbitration agreements and sort of refused to consolidate and divide the claims. And in fact, there was a decision which had come on my review where the ADGM courts had actually said, and I quote this because it was really interesting, where the court said it's widely recognized that fragmentation is a price to be paid for the policy of enforcing arbitration agreements. And obviously that's a really pro-arbitration decision from the courts, but I don't necessarily agree because I don't think fragmentation is the price that we need to pay for being pro-arbitration. And in fact, it shouldn't be. What we really need is a proactive judiciary, a judiciary that's trained and attuned to these issues to really come in, take a deep dive and divide and delineate the issues to the extent they can, of course, because there's always a way to the extent possible to delineate these issues. I mean, it's never going to be that a subcontractor's claims would 100% relate to a main contractor's claims. So the answer to your question is we're going to see a lot of these sort of parallel proceedings. We're going to see a lot of these challenges, in my view, especially with the rising cost of all of these items related to the construction industry. And I think really going forward, it is for the courts and judiciaries to take a proactive approach to divide the main contract proceedings and the arbitration in a way that's sensible, in a way that doesn't obstruct the pro-arbitration regime that we currently have going towards in the region.
Absolutely. Yeah, I think it's fascinating. And I think, that's a perfect segue to Gianna's presentation about Dubai and all of the developments that are going on in the UAE generally and what she's seeing on the ground over there. So Gianna, I'll turn the mic over to you to share a little bit about what you're seeing and the developments.
Hello, everyone. Thank you for being with us today. Thank you to the World Arbitration Update. Thank you, Randa. Thank you, Randa, and particularly for calling my part Dubai trends. Well, when you come from Dubai, all you talk about is that trendy Dubai that you live in. Well, in fact, Dubai has been trendy in every way, to the extent that we've seen the abolishment of what I may call an arbitration center, two arbitration centers at once, in a city that chooses to be trendy, that chooses to find a way to evolve in its own way. Now, Khushboo could not resist talking about the abolishment of the two arbitration centers because they've been the highlight of the whole year in arbitration, to the extent where the latest arbitration conference that took place in Dubai, the Dubai Arbitration Week, was mainly all about these two centers being abolished and the 34, the cabinet decision for that purpose and the rules that followed. Now, I have witnessed personally the birth and demise of arbitration centers. In 2002, I joined the Chamber of Commerce when we had something called the Committee for Conciliation and Arbitration. It was so, I'm not going to call it primitive, it was so, at that point, the happening thing in arbitration in the MENA region. Dubai took the first step. We were there when nobody actually thought of it seriously. I worked with the team on setting up the DIAC, which I have to say, during the last, now I can say 20 years of my practice, I have seen DIAC at once, in my opinion, at that time, it should have been, finished. But then I saw the rebirth of DIAC, while at in 2008, when I joined the DIFC, at that point, I was part of the team that set up the DIFC LCIA. And that at that time, it was the happening thing in the region to have the LCIA come to the region and partner with DIFC in setting up the first arbitration center of its kind. And it was a joint venture at that point. And now I see the demise of what it was called later, the Dubai International Institution. It's like the Dubai Financial Center Institution, Arbitration Institution. So I've seen it all. I mean, I actually wrote a bit of it in the Arbitral Women. It was a book that was published 4 or 5 years ago. And I wrote about how I was involved in setting up the 2 arbitration centers that I used to call my kids. Like I have my 3 kids and my 2 arbitration centers. Now, the DIFC and LCIA, which is the Dubai, gosh, if I can just say it right, the Dubai International Institute, as it was called, and the Dubai Maritime Institute, they're gone. They're not there anymore. What does that mean to us? Honestly, for practitioners in arbitration, I actually act as an expert in most times to give an expert opinion to many courts internationally in arbitration in the region, where I would speak about jurisdiction, where I would give an opinion on the laws that are in place for arbitration. I have to say, I've seen it in Dubai. I've seen the 2008 or the 2006, Khushboo, I'm not sure, when we became signatories to the New York Convention. Then it took us almost 8 years to have our own arbitral law, the federal arbitration law, when most of the region had laws. Okay, it took us forever, but we have always been there. Arbitration has been the UAE, whether it is, I mean, Khushboo mentioned them. It's we've got the ICC now having its own office in Abu Dhabi. The ADGM has its own arbitration. We have the courts, we have the DIFC courts now as a default, according to the new rules, which is, and of course we have the arbitration law, the federal law. Now, where is the future? Where do we believe the UAE is going? Is it gonna minimize arbitration because of the precedents that we've seen lately, where the courts are still resisting the fact that arbitration can be the ruler, has a ruling role in the jurisdiction, in our courts, or we're going to have a pro-arbitration environment, whole jurisdiction that really supports arbitration. Remember, arbitration is the alternative. Arbitrations to many was supposed to be a trend 20 years ago, when I remember how it used to be for me in the Chamber of Commerce. All these amazing, businessmen that we used to sit on these committees would just say, it's just gonna be a trend and it will fade. It will go away. Arbitration will not last. So just don't spend a lot of time and effort on it. We've seen it happening. The whole region is adopting arbitration and trying to groom it into what could be, just an equal to litigation. Now, everyone here must have some practice in arbitration. Do you think with the COVID, with the online, with the fast track rhythm that we see in courts now, how would arbitration weigh in such terms? Would it still be that better alternative? Are we gonna say one day our courts are doing what arbitration does? It's actually less expensive. It may be better to just include litigation for dispute resolution rather than arbitration. While we're seeing still in the region the trend of the courts not to take arbitration in and just accept it and give it that way that it deserves in terms of, when it comes to judgments, we may find ourselves in the region just going for a setback in arbitration because the courts are becoming far competitive. in its own way of running itself online, the ability to just have a Zoom and get, litigants from all over the world sitting on one Zoom discussing a case. That was not even thought of. I mean, 2 years ago, would have ever thought of something like this. I was just telling Randa today, I just was speaking to a judge a couple of weeks ago, and he said, oh no, no courts anymore. Physically, you will not be required. I'm like, we're not gonna open our courts? He's like, not really. I don't see us doing it. And that is in Dubai. Now, the 2 points that I would like to highlight, because I have to say that Khushboo actually hijacked my part of the, but anyway, Khushboo, we're still friends no matter what. So we've had always the DIFC courts with an allegation, a claim against it, doing that conduit jurisdiction role, which was highly criticized. I mean, nobody wanted to feel that you're just getting all these judgments from abroad and throwing them on shore just because you have that conduit role that you're playing. Many lawyers, many judges, many practitioners were just against it. Now I can see, because we're saying that the DIFC courts is the default in arbitration, the conduit role will not be so probably needed to be used, and because everyone will just opt to DIFC instead of just getting judgments from abroad to use it through DIFC. And plus I can see that things are going to change for the judicial committee, which is what was mainly the role of the judicial committee, was to look into this conflict of judgments that were issued by Dubai onshore and the DIFC courts judgments offshore. The ADGM is also has, maybe I should mention that the ADGM interestingly has what the ADGM has actually stated clearly, that we will not be used as a conduit jurisdiction, and that is part of its law, of its rules. And now I can see that the DIFC would not really need to play that role anymore. I can probably just say the words I've actually summed up my review of the MENA region in one of the publications that I've contributed to lately. That the outbreak of the global pandemic in 2021 and its impact on arbitration is yet to be seen as far as courts are concerned, and what the way would be forward for these two competitors in jurisdictions worldwide. And it's going to be quite interesting for all of us to see what will come out of it. Thank you. Sorry for bombarding you with a lot of news.
No, it's all fascinating. And like you said, what happened in Dubai just really took over the news in the arbitration world, particularly in the MENA region, but globally. I mean, it really did send waves across the industry that things could just be upended like that and just change without any notice, with people with pending cases or contracts that didn't account for these changes. And it's certainly something that I think all parties now need to be prepared for, that these types of changes might happen overnight almost, and they have to be resilient and figure out ways to respond and to react. And that leads me to a question that I've personally wondered, and I know that our clients and practitioners and stakeholders in the region are interested in, which is, in light of what happened in Dubai, how should people working in Dubai or who have in the past viewed Dubai as the reliable and stable country in the region, the one that we can count on to not have these types of changes on a whim, so to speak? Perhaps it wasn't on a whim, but it was a surprise. How is that going to impact the perception of Dubai as an arbitral hub in the region? Also, in light of what Khushboo and you, Gianna, talked about with respect to the shift in court decisions not always appearing to be the most pro-arbitration. Do you think there's a chance that parties will start to shift away from choosing Dubai? And Gianna, I'll let you start. Yeah.
Yeah, I do not see that happening. But I'm not trying to defend our legislator here, but I would want to say that arbitration can be like Dubai as a host of an arbitration of arbitration and as a leading hub for arbitration would not actually lose its stand just because they decided that the multiple arbitration centers will not serve the city, serve arbitration. So the fact that we've had a number of arbitration centers was seen to be a less use of resources, and to just have one arbitration center with what Khushboo actually mentioned, and I would mention it again, having its own court where the decisions, although this may be criticized later, I mean, there's already the criticism that's coming. Why would the DI, why would DIAC have a court that would decide on the validity of certain awards, or if they are good enough to be issued? But I believe what arbitration needs, and we all agree here, that arbitration needs sometimes more regulation, not less, in order to have that credibility and for people to trust it. Because we need the judges to have that trust that the arbitrators that are in place are actually qualified, are people who have been chosen because of criteria that are not loose or not acceptable, that these tribunals are good enough and they've been doing their job properly. I don't see any harm in that. The less regulation is better, but a certain regulatory mechanism in place would actually serve arbitration, not put it, as a lot may imagine, at the bad end, or the negativity that may be attributed to it.
And Khushboo, I know I want to give you an opportunity to respond as well, given you practice in the area, of course.
Yeah, I mean, there's lots to say, but essentially, I agree with Diana. I mean, I think there should be adequate regulation, but I think what else needs to be done is training for the judiciary. And I actually come from Singapore, and Singapore is obviously a really pro-arbitration jurisdiction. It's up there in the likes of Paris, New York, London as centers, and I can tell you, it just didn't come about from thin air. The Singapore judiciary got training, proper training. The judges were trained in arbitration. We picked judges who were experts in arbitration to then sit in our high courts to rule on setting aside and decide on these sort of issues. And that really needs to happen. And I've seen judges come to Singapore from South Asia. I've seen judges from Qatar come to Singapore for this sort of training, and that really needs to happen. I'm not saying the UAE hasn't done it. I just think there needs to be a lot more training, together with some regulation, to bring it to where it needs to go. Because I think the UAE's vision it's great. And when we see this in all the legislations and laws, they've got such a great vision. They know where they want to bring their country. And we see the fact that they have changed their working days from Monday to Friday this year. They obviously want to make Dubai or the UAE one of the financial centers and cities in the world, but there just needs to be some sort of more extra added measures to bring it there. And once that happens, I think it will definitely go there. But just generally on what's been happening with decree and the perception from our clients, I can tell you the short-term effect of when this decree was issued was obviously there was a great deal of uncertainty. Clients would come to us, they wanted to opt out of their Dubai arbitration clauses. We were looking for alternatives. But I think recently, especially I'd say in the last few months, the region's bouncing back with a sense of confidence and sureness of what it wants to achieve. And we see parties, we see clients now whose projects are in the region and they want to arbitrate in the region. Their preference is still to choose the DIAC, the ADGM, or the ICC with seat, with laws in the region. And I think there are really two reasons for this, if I could say. I think the first reason is just the perception people have is that they think they need to opt for regional arbitral centers, rules, and seats if their project's based here. But I think there's also a second reason, it's a bit more practical. And I think that is that they don't want to start looking for different lawyers in different countries. They don't want to start sourcing for that. So they're already comfortable, let's say, with our firm, El Tamimi. Okay, well, then they want to choose us. They want to choose the regions or our UAE laws as the governing laws, the seats, so they don't have to pick another law firm. They just want to go with the same sort of, it could be a different lawyers in the same firm, but they just want that sort of transition. So it's not like this is going to make, I mean, long term is not going to have any adverse consequences. I don't think so. I just think it's a matter of bringing Dubai and bringing UAE where it really should be.
Great. Thank you. That's fascinating. And I'm looking at the hour, so I want to make sure we cover our other regions. There's so much to discuss about what happened in the UAE and where it's going, but let's switch to North Africa and talk a little bit more about Egypt. I know, Mustafa, you already started to tell us a little bit about some of the changes that have been going on in Egypt, and the consolidation that you mentioned in terms of a little bit more government control. Please elaborate a little bit more on what you're seeing happening in Egypt in the recent times.
Thank you, Randa. I guess I've covered the part that is related to the control over the agreement between the government or governmental entities and the companies where the government is contributing with any shareholding and foreign investors. And the new thing, as I said, it's the adding determination into the list for which the such entities would need to apply for an approval before proceeding with them. And now, because we don't have a lot of time, I will just speak about recent developments in both the arbitration practice and in some developments in the Egyptian jurisprudence, either by the Court of Cassation or the Cairo Court of Appeal, which is the court that has jurisdiction to review the arbitral awards for annulment in case of annulment challenges. So in relation to the arbitration practice, what we have seen recently is growing use of technology and communication technologies and such kind of new applications and tools in both arbitration and litigation, but it's very growing in arbitration. And I remember back in 2017, 2019, when we had a hearing and some witnesses could not appear physically before the tribunal, we had to make applications and rebuttals in order to convince the tribunal that cross-examining certain witnesses by video conference is okay and fine under the ICC rules. And by the end of the day, the arbitral tribunal approved or accepted our application, and a couple of witnesses I remember have been cross-examined this way. They had some concerns to be in Egypt back then, and I remember this were the reasons, but this was not disclosed to the tribunal. So by the end of the day, this was something new for us to see in 2018. Recently, in 2022, the Court of Cassation in Egypt clearly said that cross-examination by video conference and virtual hearings are becoming normative and are becoming and are trending now. The tribunal says trending. These are the modern trends in international arbitration, that using virtual hearings and using cross-examination by video conference and new technologies. This is very interesting for me to see this in the jurisprudence of the Court of Cassation. And maybe this is because we are now having a lot of judges who have studied abroad and who are well learned in international arbitration, and they are reading and exchanging with lawyers, and they are receiving trainings and everything in relation to international arbitration. So we have this now in Egypt. So the judges of the Egyptian Court of Cassation are not that conservative when it comes to new technologies, new developments, new trends, international arbitration. They try to keep our jurisprudence and our system up to speed with other systems in the region and internationally. this will take me to the next point. I will very quickly speak about 3 or 4 points or principles where the Egyptian Court of Cassation or the Egyptian Court, the Cairo Court of Appeal made or spoke about developments in international arbitration. The first one is where the Court of Cassation said clearly and expressly that the Egyptian courts and the Egyptian legal system adopts a pro-arbitration policy, that allows, the court said that the international arbitration, the arbitration is becoming the original mode or one of the principal modes, and maybe the original mode for settling commercial disputes, international commercial disputes. Another development by the Egyptian Court of Cassation relates to the application of international rules and guidelines, like the IBA guidelines of conflicts of interest in international arbitration. The court clearly referred to clause 3.3.5 of the rules and applied it, and then made its decision on the issue before the tribunal. The issue very quickly was that one of the counsel of one of the parties, the law firm of this counsel, included a family relative of the chairman of the arbitral tribunal. So the court applied these rules, and then it said there was no conflict of interest that could cause the arbitral award being annulled or anything. So this was also very interesting. A new ruling also by the Egyptian Court of Cassation in relation to international arbitration. The court said that the parties could be represented by foreign lawyers, and you were representing, I know this, you were representing with us certain clients here in Egypt, and you are not licensed to practice in Egypt. And so the court confirmed this. Foreign lawyers can work before arbitral tribunals in Egypt without this being, without this causing any issue for the arbitral award. And finally, very quickly, there is a judgment that is very interesting by the Egyptian the Cairo Economic Court, where the court has appointed one arbitrator for in a 3 members arbitral tribunal. The arbitrator was appointed for 8 respondents. One of them was the main debtor, and the 7 other respondents were sureties for the main debt or the main agreement. And the tribunal said, the court said, sorry, that we see that they are sharing the same interest, so we can appoint one arbitrator for them all. And this was a new thing to see by an Egyptian court in relation to an ad hoc arbitration, by the way. This is pretty much the main developments that I can share in relation to the Egyptian legal system. And if you have any questions, I can gladly answer.
Thank you so much, Mustafa. You know, I have so many questions. First, I want to say thank you. It looks like I'll be welcome back in Egypt after all. And I look forward to that. But I do have many questions. I think it's really interesting. You've mentioned some developments that appear to be extremely pro-arbitration and including, you know, a policy in favor of arbitration, but also it seems that there's also some decisions that might cut against arbitration being favored, especially in the investor context. And so I find that that juxtaposition of decisions and sort of a conflicting movement in the country to be fascinating. Hopefully we'll have more time at the end to discuss some of those issues and ask some questions, but I do want to make sure we cover our last region, which is Qatar. and cover some of the developments there, and then make sure that we ask some general questions and see if anybody in the audience has any questions as well. So I will shift gears to Professor Ilyas, and I welcome him to share his thoughts on some of the developments taking place in Qatar.
Thank you, Randa, and everyone for joining whatever time you have in your own respective zones. So I think the greatest development in Qatar of the last year has been law number 21 of 2021. This was at the end of December 2021, where a new court was established, and this was the Trade and Investment Tribunal or court. Now the name is misleading because it's not supposed to be an investment tribunal as such, although in theory it may take up investment disputes between foreign investors and the Qatari state that are not subject to BITs or FTAs, assuming there's an FTA with Qatar in the future. But what it does is that it creates a third tier of dispute resolution. So apart from the Qatar Financial Center Court and apart from the ordinary courts in Qatar, so the idea is to provide investors, but effectively, investors in disputes with other entities, not necessarily against the state. But given that Qatar is a state-run state capitalism, so a number of disputes are going to be with state-controlled entities and state capital. So this is a significant new mechanism to bring effectively commercial and trade disputes before a neutral forum and not before the ordinary Qatari courts. Now we don't have much information about this court for a number of reasons, and I wasn't able to find even the law itself in Arabic. So we know that the number of judges who've been appointed so far are Arab speakers, but given that many of these disputes are going to be in English, especially because the contract may be in English, so it's surprising that no English-speaking judges have been appointed yet. So that's something to be seen how this court actually operates in the future. But it's a significant development, I suppose, and it's the entire philosophy of this is to cater to foreign capital, private capital coming into Qatar. Now that's a real development. So the rest of my presentation is about things that I hope will be useful to our colleagues who might be thinking of maybe something that may drive business forward. So one of the things that's been discussed significantly is the promotion of Islamic finance arbitration. Now there are laws on Islamic finance within the QFC. But to my knowledge, nothing significant has taken place. And something which is not related to Qatar, which might drive developments, is there is a push in Pakistan to set up a DIFC Pakistan tribunal related to Islamic finance disputes through arbitration. Now we know that all the previous developments, especially in Asia, have largely failed for a number of reasons that we don't need to go through at the moment, but this looks like a promising development. And I'm guessing that countries in the region, in the MENA region, will see this as a business objective and will try to perhaps take back some of the business from Pakistan if that kind of development goes ahead. It seems to be going. I'm advising on some aspects of that. So it's interesting to see, what happens, because the Islamic finance arbitration business isn't huge, but it's mostly driven to London, with arbitral clauses, with dual law, so mainly English law and some elements of Islamic law as well. And we see that English courts currently are taking hold of this, and they are finding ingenious ways of having Islamic law be consistent with with very old common law, to be honest. So I think that's something for people to follow. The second issue that's on the grapevine is how should Qatar kind of renegotiate existing mega sport contracts or new contracts, given that it's the big vision of Qatar. One of the big visions is, when we talk vision, for those of you who are not familiar with the concept, so countries in the GCC have a constitutional document which is called the vision, and there the policy or the economic policy for the next decade or 2 decades is set out. And so this is taken very seriously, and all financial endeavors are based on these national visions. And so one of the national visions of Qatar and also in the region is the tourism as well as mega sporting events. And so given the number of disputes that can be raised from these mega sporting events, I think it makes business sense for a country to bring these disputes, instead of taking them to CAS in Lausanne, to bring as many as it can to its own jurisdiction. So I think that's an ongoing discussion. The problem is that none of the entities so far, so clearly the local arbitration can handle this, so the Chamber of Commerce, and at the same time, the QFC hasn't shown any real interest in this. And so there is an issue whether or not there should be a kind of a mega sporting arbitration venue, much in the way that it's modeled in CAS, to take charge of this dispute. But to do that, of course, you need to renegotiate existing contracts, and at the same time impose this new arbitration clause in future contracts. I think it's certainly doable, and it's what kind of Qatari government is thinking at the moment. And I think the final, which is possibly what I'm thinking more than anybody else, is the business human rights dispute settlement. We know, of course, for the mega sporting events here in Qatar, it's been a huge amount of speculation and also controversy about business human rights. So people working in these mega sporting events, and I think it's something that could be resolved through arbitration, especially on a mass scale, and that would actually diffuse effectively what Qatar cannot do, which is bring into effect legislation for collective labor rights. So I think in lieu of the lack of collective labor rights, business and human rights arbitration is a viable alternative where you have effectively these rights, but through arbitration, because you get a common lawyer, you're able to pay for it, and the corporations are able to put some money on the side on their own will, not as to go against the law, but effectively to assist in getting those rights through. That's it from me.
Thank you so much, Professor. I mean, it's fascinating to see, while there hasn't been a lot of express change recently in Qatar, there is also, a tide of change to look forward to in the future, particularly with these mega sporting events, like you mentioned, and also something that Khushboo mentioned in her initial presentation, which is that there's been a lot of decisions coming down from the courts that appear to be extremely pro-arbitration. And so I'll revisit and then sort of reframe a question I raised to both Gianna and Khushboo about, the changes in Dubai and how that might impact the choice of Dubai as a hub for arbitration. Do you think that some of these changes and developments in Qatar, including in both the jurisprudence as well as these forward-looking potential developments that you mentioned, do you think that might attract more arbitration to Qatar, and that's something that Qatar is looking for? And I'll start with you, Professor, but then I'll open it up to the other panelists if they have any thoughts.
I think Qatar at the moment hasn't thought about the idea of bringing in more business in terms of arbitration, and I'm not saying that because they can't. It's because they've obviously branched out quite a lot with all the things that they're doing, and it's still a small country. But I think that's the idea, and the QFC. I think the idea was, of course, to bring business, and you have this amazing panel of judges as you have throughout the GCC, of course. But it's not really making up. The caliber of the people there and the amount of cases it handles, I think it pales into comparison with other jurisdictions, the London Commercial Court, for example. So I think there's a lot more that can be done, but I don't think there's a focus on that at the moment. But certainly in the next 5 years, after the World Cup, I think that's where it's all going to go to.
Right. Of course, we can't talk about Qatar without discussing the World Cup at least once. I was trying very hard to avoid it, but it was bound to come up. Does anybody else have any thoughts about that shift? I don't know, Khushboo, did you have any thoughts in light of your commentary earlier about the changes and the recent decisions that have been coming down?
Yeah, sure. I mean, I agree with Professor Liaz. I think Qatar can do a lot more, and I definitely wouldn't think it's the go-to place for arbitrations. But I think the arbitrations that are seated in Qatar, I think what it's trying to do is the government or the arbitral centers and judiciary are all trying to open up this perception that they are pro-arbitration. And I think we see a lot of these judgments that are streaming along, giving the same sort of message to the wider audience that have Qatar-seated arbitration clauses in their agreements. And I think I mentioned recent judgments about how the courts have refused to set aside an award that was just not issued in the name of Emir, but not, it just doesn't stop there. I've seen judgments that courts have refused to set aside where, for instance, there's been a failure to appoint a Qatari lawyer. That's no longer a reason now to set aside award, even if you don't have local lawyers on board in your arbitration. I've seen another recent judgment where the arbitration clause is actually extended to third parties. There was not even a party to the clause at the very beginning, just as a way to preserve the arbitration award and not attack the whole proceedings that took place. So I think there's been a shift generally for the last 5 years since the Qatar Arbitration Act was enacted. You can see the judiciary's gotten that message through the systems, through the government, that they're not meant to attack the arbitration process. And that's obviously very welcomed, and it's obviously going in the right direction.
Yeah, I think that's exactly right, and I think we're seeing that, and over the next few years we'll probably see even more of that. So since we have a few minutes left before we all break off into networking, I would love, just in one sentence, if each of our panelists could share maybe one development in the region that they think that every arbitration practitioner should watch out for and keep in mind in the years to come. And we'll start with you, Gianna, because you're smiling.
The one thing for us as practitioners in arbitration is to remember always that arbitration is the alternative to the justice system, which is all about sovereignty. So every country believes in the Middle East and in North Africa that the justice system is part of me, part of my sovereignty. So when an arbitrator who is God knows who comes and has the same, role of a judge in my court, it's going to take time. And we've seen in every country, in the GCC, in the Arab world, in North Africa, that there has been a downfall and a pickup somehow. So for me, for any practitioner in arbitration, please, before you take on a job, whether you're an arbitrator and a counsel, please read about that country, that jurisdiction. You will read history. Remember when everybody said that law without history would never make you a good lawyer. So literally, that's what you should do. Read a bit of history about that country that you're gonna be working with in your arbitration case. It will help you a lot. And there's so much has been happening, and I'm glad to be sharing it with everyone here. Thank you for the opportunity.
Thank you. Why don't we go to Professor Ilyas?
I think that despite the negative connotations in the West about the Arabian Gulf, as a Greek, I called it the Persian Gulf, and my students got crazy.
Yes, I would go crazy too. We all Persian Gulf, Arabian.
But nonetheless, this is the safest place in the world to live, but also to do business. And I think, Randa, you mentioned at the beginning, it's the fastest growing, part of the economy globally, and there are reasons for that. So I think, the future is in the MENA region.
Wonderful. Khushboo.
So for me, arbitration really sits within the spectrum of alternative dispute resolution, ADR, and I think the different pieces of ADR really need to go hand in hand. So arbitration, mediation, negotiation. The ultimate goal is really to find a commercially sensible way to resolve parties' dispute, and I think parties shouldn't just look at these options in silo. They all should be looked at holistically, and that's something which I think people should look out for and be particularly attuned to.
Great, and we'll end with Mustafa. Thoughts on the question?
Yeah. So in one sense, growing the use of technology in the coming years, more and more, I guess, as Diana said, they're in Dubai, they are using technology instead of going to their courtrooms. I guess we will go this track in international arbitration, maybe in Egypt and in the region in general. Another thing, very quickly, the relationship between the international arbitration and the enforcement of international arbitration awards and the court systems. This is a big issue that we should watch.
Absolutely. And I mean, to the point of technology, we are having this conference on Zoom, which I think says it all. We debated having it in person, but ultimately we were all able to gather virtually, which was certainly lucky for all of us, given we're all in different time zones, which made planning quite a fun endeavor, I'll say. Well, I want to thank everyone for joining us today. We're at time. And it was such a pleasure learning from all of our panelists. Thank you so much for your work on these presentations and for sharing your thoughts and experiences with all of us. And thank you to our organizers for inviting us and letting us have this very interesting and timely discussion. I think in terms of next steps, we'll move on into breakout rooms and we can continue the discussion there and get to know one another.
Thank you, Randa, and thank you in the order that I see you, Professor Elias and Gianna and Mustafa and Khushboo for making the outlook on international arbitration much closer to home and sharing with the rest of the world the different variants of international arbitration, including commercial arbitration, but not only that, also investor state arbitration and the various setbacks and rebirths of arbitration centers in the region. Something known for everyone, and also despite that, making the point which is a very important one, that it's an exponentially growing region in terms of economic growth and also business and therefore also arbitration and adjudication on business. Thank you very much. I think that we now can move on to possibly what might be two or one big informal sort of breakout room. This is where our recording stops, and then we can kind of be more at ease. There is no agenda for the breakout room, so everything is really up in terms of networking. Some people really want to meet you or ask questions, etc. So we'll go into that right now. Again, thank you, and hopefully as